Welcome back to Sunrise, and for our issue of the week this Friday, we take a look at a very important issue, as Mark has already said. Now, imagine being 5 years old, sexually violated and unable to make sense of the crime, or even being aware that it is a crime. Now, the feeling of frustration and despair has finally come to an end for most sexual abuse victims. The Johannesburg High Court declared the 20-year time limit for reporting sexual abuse crimes unconstitutional, and even though they have to wait 18 more months for it to be amended, this is a victory for many people. Now, joining us in studio to talk more on this act and how exactly it will work is activist Vincentia Dlamini from Women and Men Against Child Abuse, and attorney Ian Levitt from Ian Levitt and Attorneys. Good morning to you guys, and thanks for joining us. And we're also taking your calls this morning on 011-447-1742 or 011-447-1620. Your comments are also welcome on our Facebook as well as Twitter pages. So now, to kick off our conversation, Ian, I want to start with you, because we always get caught up in the terminology, and then when it gets to the legal side, sometimes I'm like, okay, am I saying the same thing or not? Sexual assault versus sexual abuse, sexual offences. These are interchangeable words. Does it mean the same thing? And legally, what do we need to understand so that when we talk about what happened with this case, exactly we describe it the best way that it sort of like gives it the weight that it deserves?
So the differentiation is really penetrative sexual assault or sexual violence and non-penetrative sexual assault or sexual violence. Before the amendment of the Sexual Offences Act, it used to be indecent assault. It's now called sexual assault. So it's interchangeable really.
Okay. All right. So, and now, Vincentia, let's sort of like bring you in there into that conversation. A lot of times, describing, you know, and going through the cases in terms of like what happened to victims, it takes a lot of like, you know, psychological challenge to get through it and be able to get the support that they need to go to court. What just transpired with this case? What does it mean for victims of sexual abuse?
As you've mentioned, this is a landmark case, and it's victory for them, because we've seen how the criminal justice system has been, and we had a law that was less sympathetic to victims of sexual assault. And, you know, it's easier for courts to be sympathetic when it's penetrative rape, but the effects of sexual assault, because if you're sexually assaulted, especially by somebody that you trust, then there's a lot of emotional issues that you have to deal with, and it's a lifelong, it has lifelong effects. And then we shouldn't minimize the ramifications and just think rape has more ramifications than sexual assault. So they should be treated equally, because they have the same lifelong effects on the victim.
Okay, now in terms of like the takeout and what we can learn and understand from this landmark case from a legal point of view, obviously it's very empowering for victims who feel that, yes, I was assaulted, I might not have been, you know, penetrated, but my rights were violated. What do we need to understand of the outcome?
What people, I think, would gain from understanding this case is the following: that first of all, you have to have a case that is prosecutable and a reasonable prospect of success. So when people think, well, after 20 years, they think the 20-year period might be relevant because there's no evidence after 20 years. Sometimes there's no evidence after 2 years. So the point of this whole case is that if there's good evidence, whether it's 2 years, 19 years, or 21 years, there shouldn't be a bar on the National Prosecuting Authority, who has the discretion whether or not there's a good case to now institute prosecution against the offender.
So, Vincentia, let's talk about that time period. Okay, so this 20 years has been scrapped, and a lot of people have been saying, I mean, really, 20 years down the line, could you even still remember? But like, just take us through what the victim goes through and why some people would not understand that actually it doesn't matter whether it's 50 years down the line.
Okay. We know that 80% of child sexual victims are victims of the crime that has been committed by somebody close to them. That would be your uncle, your family relative, your neighbor. And that person, that relationship of trust, there's issues there. You violated and you're powerless at that time because, for example, you mentioned a 5-year-old child. We can't expect a 5-year-old to defend themselves against, against the offender. So at that time, obviously, you are powerless in that position. And one, you are prematurely exposed to sexual acts. And as a child, that emotionally, psychologically has effects on you as a child and how you're going to form relationships, how you're going to have like meaningful relationships as you grow up. Some of the victims that have been sexually violated as children are going to suffer depression at times. Mental illnesses, are going to sometimes abuse substances, alcohol, and just have self-destructive at times. So that is why this is very important. It doesn't matter that it's 20 years. It means that the victims has suffered and they cannot be unsuffered. So why do you have a 20-year limitation to say after 20 years it has to lapse? But the effects are still there. It doesn't mean it's taken away. It has lifelong effects. So that 20 years, we're happy that it has been scrapped. It's unconstitutional. And you know what, after 20 years, when you really feel that, when you've grown up and you really feel that you've got the power, you've got the strength to face your offender as a child, there shouldn't be a law that is going to say you can't. Like you're 5 years old. Now you say 26. You're 26, you want to take it up because you feel that, you know what, I know my rights, I have support, I have an organization that is going to, I have means, I can go and approach attorneys that are going to, why should we have a law that says you can't do that when you actually have been sexually assaulted? I think the next step is just going to the local police station. And because after 20 years, people could have left maybe Maduba and they're now in Joburg. And I think they should know that they have a legal right to open a case where they are. Then it is the police responsibility to take it to Maduba or wherever where the case happened, because most of the time police officer says, no, you have to go there to actually lay these criminal charges because this is where it happened. So they should know and should not feel hopeless and say, but you know what, how do they expect me to take a bus and go back there? They should know that this is their right, so they can.
As much as it is their right, a lot of victims, of sexual violence feel that they don't have much confidence in the police. So maybe when we come back after the Afrikaans news, Ian, we can talk about, what are the legal steps that they can take, collectively working with the police to actually, if they're empowered to be in that position to consult a lawyer, that this is what I can do to actually get justice served for them. Conversation before the break, Ian, and the question was for you in terms of like how legally, the victims can be empowered, whether this case was 20 years down the line or 30 years ago, the process that they have to follow and what they need to how they need to prepare themselves to deal with that.
Well, what they could do now is that they would approach their local police station. They would lay a charge. They mustn't worry about that they can't remember the exact day that it happened. They must just go and tell the story as they remember it. There's no concern that because they didn't know the exact time of day, the exact year. Often, as the first part of the segment, it could happen to a 5-year-old. No one can remember the particular exact day, and how would they be able to remember which month or possibly even which year it happened. So they shouldn't worry that that is a hindrance in the ability to lay a charge. They should go to their local police station, and the local police station themselves will then transfer it to the jurisdiction, the correct jurisdiction, and it will be taken from there. At the present moment, I'm actually aware that this judgment is presently being circulated around the courts in South Africa and around the different police stations, so that the police commanders and the police station commanders know exactly how to handle these cases. I'm hopeful it may not be by Monday that everyone's aware of this, but they should be aware of it. But it's certainly gaining momentum, and they will be aware of this.
So obviously, Vincentia still has to go through the Constitutional Court and go into the National Assembly. What does that process entail, and what do we need to understand about that?
We need to understand that until Parliament has actually made it into law, that we can then start with the process of actually laying criminal charges. But I think because of the 20 years, which is unconstitutional, I think we can also be a little bit patient with 18 months, that even if it happened 21 years, so 18 months, so we're hopeful that by then it will be. So I think currently people can just prepare themselves whilst we wait for Constitution to make it into law.